Good day, and thank you for watching. If a trust was changed before a loved one passed away, and something about that change doesn't feel right, you need to understand how trust amendments work in California and when they can be challenged. A trust amendment is a change to an existing trust. It can modify who receives assets, how assets are distributed, or who is in control. And in many cases, these amendments happen later in life. That's where concerns often arise. Let's start with the basics. A person who creates a trust, known as the settlor, generally has the right to amend that trust while they are alive, as long as they have the legal capacity to do so. That means they must understand what they are doing and the effect of their decisions. But here's where things become more complicated. Not all amendments are made under clear and fair circumstances. Some may be the result of pressure, manipulation, or diminished capacity. And when that happens, those amendments may be subject to challenge. Let's talk about one of the most common issues: undue influence. Undue influence occurs when someone exerts excessive pressure on the person creating or amending the trust. This often involves a situation where one individual has significant control or access, especially when the settlor is vulnerable. For example, an elderly person may depend on a caregiver or family member. If that person is involved in making changes that benefit themselves, that raises questions. Now, let's talk about capacity. For a trust amendment to be valid, the person making the change must have the mental capacity to understand what they are doing. If there are concerns about cognitive decline, illness, or confusion, that can become a key issue. Medical records, witness statements, and other evidence may be used to evaluate capacity. Here's where many people make a mistake. They assume that because a document was signed, it must be valid. But the law looks beyond the signature. It looks at the circumstances surrounding the change. Who was present? Who benefited? What was the condition of the person making the change? All of these factors matter. Now let's talk about timing. Timing is critical in trust litigation. If you believe an amendment is invalid, you cannot wait indefinitely to act. There are deadlines that may apply. And if those deadlines are missed, your ability to challenge the amendment may be limited or lost. That's why recognizing issues early is important. Now let's discuss evidence. Challenging a trust amendment requires more than suspicion. It requires proof. That may include medical records, communications, prior versions of the trust, and testimony from individuals who were involved or observed the situation. You are building a case, and that case must be supported with clear and convincing evidence. Now, let's talk about the role of the trustee. If a trustee is involved in the amendment process, especially if they benefit from the change, that can raise additional concerns. Trustees have fiduciary duties, and those duties require them to act in the best interest of the beneficiaries. If there is a conflict of interest, that may become part of the analysis. Now, let's address another important point: prior documents. Earlier versions of a trust can be very important. They show what the settlor intended before the amendment. If there is a significant and unexplained change, that may support a challenge. For example, if a long-standing plan is suddenly altered in favor of one individual, that may raise questions. Now, let's talk about strategy. Challenging a trust amendment is not just about identifying a problem. It's about presenting a clear, structured argument supported by evidence. You need to understand the legal standards. You need to anticipate defenses, and you need to be prepared to present your case in court. This is not a simple process. It requires careful preparation. Now let's discuss outcomes. If a court finds that a trust amendment is invalid, it may set aside that amendment. In some cases, the trust may revert to a prior version. In others, the court may take additional steps to ensure a fair outcome. But again, the result depends on the facts and the evidence. Finally, let's talk about the bigger picture. Trust litigation is not just about documents. It's about intent. It's about fairness. And it's about ensuring that The wishes of the person who created the trust are respected, but those issues must be addressed through the legal process. And that process requires knowledge, preparation, and attention to detail. In conclusion, if a trust was amended under circumstances that raise concerns, whether due to undue influence, lack of capacity, or other issues, you may have the right to challenge that amendment. But doing so requires more than concern. It requires evidence, timing, and a clear understanding of the law. If you're dealing with a situation involving a trust amendment, take the time to understand your position and your options. Call us at 888 6582. I'm Vince Davis, and we are all in this together.